Are you being abused or stalked by somebody and you're wondering what you can do to protect yourself? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how to file a civil protection order in Connecticut court. A civil protection order is a court order that is issued in civil court that prevents another person from doing things like contacting you in any manner, going within a certain distance of you physically, or going anywhere near your place of residence or your place of business. It's different from a criminal protective order, which is issued in criminal court in conjunction with an arrest, and it's also different from a civil or family restraining order, which is issued in family court protecting you from family or household members who have acted inappropriately towards you. If a civil protection order is violated, the person who violates the order is subject to arrest on a felony charge of violation of a protective order. Now, you're only eligible for a civil protection order if the person you are filing it against is not a family or household member. So that includes people who are a current or former spouse, somebody who's related to you by blood or marriage, somebody who is the parent of your child, somebody you live or have lived with, or somebody you have or recently have had a romantic dating relationship with. If you fall into any of those categories with the other person, you are not eligible for a civil protection order. Instead, you should file a family restraining order. I would call your attention to the video I've created on how to file a restraining order in family court. And if the other person is not a family member, you are eligible for a civil protection order if the other party has subjected you to sexual abuse, sexual assault, or stalking, and there are no other protective orders in place. So if there is a criminal protective order in place, for example, then you are not eligible for a civil protection order. Now, in order to actually file for the protection order, you should do a Google search for JD-CV-143 and download this form. And you fill it out by first putting the judicial district where you will be filing the protection order, and this is either based on where you live or where the other party lives. And if you do a Google search for the Connecticut Judicial Directory, you can find which judicial district you should file in depending on the town where either you or the other party lives. Once you've identified that judicial district, you should put the address of the court. You should leave the docket number blank because you won't receive a docket number until you file the application. The clerk will fill out this section. You should then fill out all of your basic information. So your name, date of birth, sex, race, addresses of your home, mailing address, work address, etc. And then you will fill in all of the relevant information for the respondent. So that is the person you are filing the protection order against. And then you will check off whether or not the person is a family or household member. And again, you are only eligible if they are not a household member. So look through this list, and if they fall into any of these categories, then you have to file a family restraining order. Then below that, you check off if there are any other orders in place, and if so, put the docket number and the court location. On the second page, again, put the name of the applicant and the respondent. So you are the applicant, the other person is the respondent. You can leave the docket number blank. And then you will check off the box as to the basis for why you are seeking the protection order. And again, it has to be sexual abuse, sexual assault, or stalking. And stalking is defined as 2 or more willful acts performed in a threatening, predatory, or disturbing manner of harassing, following, lying in wait for, surveilling, monitoring, or sending unwanted gifts or messages to another person directly, indirectly, or through a third person by any method, device, or other means that causes such person to reasonably fear for his or her physical safety. So obviously stalking is sort of a generic term, so make sure that you fit within that definition that is within those parentheses. Then you have to check off the second box that there are no protection orders in place, and the third box that the other party is not a family member. You then check the relief that you are seeking. So you presumably definitely don't want the other person to assault, threaten, abuse, harass, follow, interfere with, or stalk you. You may want them to stay away from your home. You may want them to not contact you in any manner, and you may want them to stay 100 yards away from you. So check off the box for what you are seeking that the court order. And then in box number 5, you can type in any other relief that you are seeking from the court. In box number 6, you check off if you want a copy of the order sent to your school. You check off box number 7 if you want immediate ex parte relief. So you want there to be court orders in place as soon as you file this application. And then finally, you sign the application and have it notarized by the clerk and fill out the information as to whether or not the other party has any firearms or ammunition. And then with the application, you have to provide an affidavit. So you put your basic contact information at the top, you leave the docket number blank. And then in the box, you need to put a detailed explanation for how the other party has sexually abused you, sexually assaulted you, or stalked you. It should be as detailed as possible, including specific incidents as well as when those incidents took place. The court will want to know the timeline of when things occurred, and in certain circumstances, it's important to know that things happened recently rather than far in the past. Once you have filled out that affidavit, you will then sign your name at the bottom and have it notarized by the clerk. Now, once you submit this to the clerk, the judge can do a number of things in the order section. It's possible that they just outright deny your application and do not schedule it for a hearing if they feel that you have not even come close to reaching the burden of showing that the other party has assaulted you, abused you, or stalked you, and they can just deny it outright. What they can also do is not issue immediate orders if they feel there is something there, but there's not enough to find that there is an immediate danger. In that scenario, they can refuse to issue immediate orders, but schedule it for a hearing within the next 14 days. And you'll go to that hearing and present evidence as to why you want the protection order in place. A third option is that the court feels that there is an immediate danger and that an immediate protection order should go into place. And in that scenario, they will issue that order that you will serve on the other party, and you will then have a hearing within the next 14 days at which you will ask that the court extend the protection order to be in place into the future. Finally, in the last box, the judge has the discretion to order that the other party surrender any firearms or ammunition. If the judge does anything other than deny the protection order outright, you have to arrange for the other party to be served by a marshal so that they have notice of the upcoming court date. The clerk can provide you with a list of marshals, so you will contact the marshal, have them arrange service, and then make sure you get a return of service form back from the marshal so that you can provide that to the court to give evidence that you had the other party served. You will then appear on the court date and you will have an opportunity to go in front of a judge and present evidence, put on witnesses who can testify, and the other party will also have the ability to put on evidence and testify. And ultimately, after that hearing, the judge will make a decision, and that decision is binding. They can either deny the protection order or they can put it in place for up to a year. Now, if the protection order is expiring, you do have the option to file for an extension by going to the clerk's office and filing for that extension. So those are the basics on how to file a civil protection order in Connecticut court. As usual, if you have any additional questions, you can contact our office. And if you are looking for a representation in a civil protection order or family court matter here in Connecticut, we would invite you to contact our office as well.